Good evening. Welcome to Progressive Soup. My name is David Stevenson. Tonight I have with me Mike DeRosa and Richard Duffee, members of the Green Party. Now, as you may know, the Green Party, amongst other litigants, sued the state of Connecticut recently regarding the campaign finance law, stating that the campaign finance law was unfair, amongst other things, unfair to the smaller parties and focused mainly on the two major parties, the Democratic and Republican Party. Mike, tell us about the suit and tell us why it was brought.
Yeah, the suit took place in July of 2006. It was actually July 6, 2006. We put in the suit. It is basically run by, I'm a litigant, the ACLU is our attorney. We also had the Green Party, Libertarian Party, also Betty Gallo, who is a progressive lobbyist, and also we had the husband of the lobbyist for the Bar Association. So we were in good stead, and basically our principal reason for bringing this particular suit was because we felt that we were being discriminated against constitutionally and we were being harmed by this law. And we can get into the particulars of why that is, but basically the principle comes down to this. The state of Connecticut is saying, David, in essence, that all political parties are equal in Connecticut, but some political parties are more equal than others. And our contention is that that's Boulder Dash. And so our judge, after 3 years and 2 months, has come forward with a decision declaring the campaign finance law unconstitutional because it violates our First Amendment rights and our our 14th Amendment rights under the equal protection provisions.
Now, if I can interject for a second, I ran as a state representative candidate last year in the 107th District and found the campaign laws to be far superior to what we had without the campaign finance laws. We had thresholds for raising money. No candidate could take any corporate money, any PAC money, any lobbyist money. The amounts were limited to, I think, $200 per person, and most of our donations were much smaller than that. But at the same time, I understand that the thresholds that were placed upon minor party candidates, Greens, Working Families Party, and some of the other minor parties, if you will, in Connecticut, the thresholds were much more difficult to achieve than it were for the two major parties, the Democratic and Republican Party. Tell us how this impacted last year, and also how it impacts us going forward with the gubernatorial race coming up next year.
That's a good question, Dave. I was thinking about what metaphor would express how I felt having run in 2008 in the 1st District for Senate in Connecticut. And I came up with this, which is I was a political crash test dummy for Governor Rell and the Democratic Party. I don't know if you can see that or not, but basically the principle here is that I feel as we're being experimented on, and I believe that one of the problems with this whole law is a sort of a double bind kind of structure in that no matter what we do, no matter which way we turn, the system is designed. This particular campaign finance law, also known as the Citizens Election Program, is diabolical in the way that it approaches stopping third parties not only from participating in the political process through exclusionary methodologies, but more importantly, it really causes us to lose our First Amendment rights. And Judge Underhill confirmed and validated this in his decision that the Citizens Election Program diminishes minor party, quote, political opportunity by enhancing major party candidates' relative strength by providing candidates with, quote, windfall levels of funding that are an impermissible subsidy for major party candidates rather than a permissible substitute for those traditional sources of funding. He also recognizes that simultaneously the law is cleverly crafted to add, quote, additional qualifying criteria for minor party candidates that are so difficult to achieve that the vast majority of minor party candidates will never become eligible to receive public funding at even reduced levels. And that's an exact quote from the case. And I mean, okay, so the question is, all right, what are we talking about here? Well, let's talk about the election in 2010, since you brought it up. For governor. In 2006, what happened was that the votes cast for Connecticut governor were 1,123,466 approximately.
That's the total number of votes
total
cast
number of votes
for all the candidates.
Right. 1,123,466. Okay, that's the number of votes. Okay, so under the campaign finance law, we as a minor party have to collect 20% of that number. So what that means, 20% of that 1 million votes plus in order for the Green Party to get a full grant under the Citizens Election Program. And if you do the math, it comes out in 2010 we have to collect 224,683 valid signatures.
That is a tremendous number of signatures. Now, just to backtrack for a second, some of the litigants in this case were people that I think it's safe to say want to not have public financing at all. They want to have corporate control over. What was your goal in challenging the law? Was it to just kill the law entirely?
No, not at all. I mean, I think the issue really is that this is not a right-wing issue. It's not a left-wing issue. It's not a right-wing issue. It's not a left-wing issue. It's a human rights issue. It's about access. It's about the Helsinki agreements. It's about the fact that this is unfair, that it's unconstitutional. And the judge has basically said, yes, you're absolutely correct. Now, of course, the state of Connecticut, in its wisdom, has decided to appeal, and they have every right to do so. But my own feeling about it is they should stop wasting the people's money. We went into court, and I looked to the left, and I saw not one, not two, not 10 lawyers. I saw 22 lawyers. And then I saw an additional 10 lawyers in the audience. Basically, this was an army of lawyers. And, of course, we had the ACLU lawyer, Mark Lopez, and .6 additional lawyer, you know, a part-time lawyer who comes in and helps us out. So this wasn't a battle between David versus Goliath. This was David versus Godzilla, all right? And we were up against an incredible attack, really, on our legal rights because they could outspend us, they could outmaneuver us, and in spite of their best efforts, they failed. And I believe that they'll fail the appellate court because this case is 138 pages long. It's very comprehensive. It shows, in essence, not only the issue of hurt or damage to us, but it also points up the fact that the judges applied strict scrutiny. And I don't have to be a lawyer to understand that. It means that we're talking about strict constitutional application of the law in this case. So he's not saying simply we were damaged. He's saying the First Amendment was violated. The 14th Amendment equal protection provisions were violated. And how violated were they? Well, let me just leave you with this last thing. The net signatures needed were over 400,000 because in the state of Connecticut, what you have is every signature has to be scrutinized by a town clerk, a registrar of voters in many cases. And of course, we know that Democratic and Republican registered voters, registrars would not, you know, stop us from getting $3.2 million by manipulating the system, by throwing off our names.
That might be a little. I think that might be a little sarcastic.
Well, I mean,
but certainly, it's an important fact to remember that that the registrars, when you have signatures, they do go through the signatures and they're looking for signatures, and perhaps, as you say, there might be some reason for them to find signatures that are not valid for one reason or another.
Now, we don't know for sure what the experience will be.
Rich, you wanted to add something?
Yes. I'd like to give a little perspective. Presently, that is in the last election, for instance, it was necessary to raise 7,500 signatures, valid signatures, to get a gubernatorial, get on the ballot for governor.
Yeah.
And there was in no case a need for more than that number of signatures. Now, traditionally, people would double that number in the expectation that as many as 50% will be knocked off. And so you'd have about 15,000 signatures going. But this is still less than 1/15 of what's being required under the new law. Secondly, 48% of the voters in Connecticut are independents. And so basically the Republicans and Democrats have combined as the single super party. They really are. The duopoly, and they've monopolized the money from 100% of the voters in the state, of the taxpayers in the state, and are using it for the will of 52% of the taxpayers in the state, leaving the other 48% out. And so monetarily, it's vastly unjust, because the state as a whole is not saying that it wants only the Republicans and Democrats. And the Republicans and Democrats are able to combine when they need to in order to exert their will together, and do so to very serious injury of the other 48% of the population.
Now let's backtrack for a couple quick questions. One of them was this army of attorneys. You mentioned as many as maybe 20 or 30, 40 attorneys that were there. Did you have any determination or any inclination as to who they represented in this case?
That's a good question. Basically, there were interveners. They represented the CCAG, Common Cause, and the Brennan Center for Justice out of New York State, which is, I believe, at NYU. And then there were some individuals that were interveners, and it was basically the SEEC, which is the State Elections Enforcement Division, and the Assistant Attorney General. And so each of them had a stake in this case, and of course we had on our side the various parties. And you know, the question is why? You know, why is all this happening? And I really don't know the answer to that. Why is a good question. I can only say to you that there is an iron triangle here, okay? And this iron triangle, essentially what it involves is, on the bottom, you've got what we talked about, the petitioning requirements. On the left side, you have additional monetary requirements, which the judge called windfall, okay, which in the case of governor, we would have to, along with all the other parties, collect $250,000 to be eligible for $3.2 million for the gubernatorial race. But basically, there's also the organizational expenditures on the right. We can get into those two other aspects of this. And so they kind of work together to make sure that no third party, now or in the future, will ever get a dime. I mean, we refer to this bill as the No Republican or Democrat Left Behind law. And for a lot of people, that's hyperbole, but it's not really hyperbole. It's really an accurate description. And the judge says in the case that, you know, the amounts of money, not only for governor or for statewide office, but also for senator and for legislature, they have no relationship with reality. They're not, in the last three races, they're doubling the amount of money necessary. So it's a kind of a candy jar, a handout program, you know, a corporate welfare program for politicians. And for a lot of us who are minor party candidates, we find this to be quite disturbing. And, you know, the judge has verified that he calls it a windfall kind of situation. And then the third aspect of it, which is particularly difficult to communicate through the media because they just don't get it, is the so-called organizational expenditures. Now, this was a gimmick that was put into the law. Quite frankly, I'd really like to meet the person who designed this. I mean, it's really a piece of genius work.
We'll talk about that when we come back. We're going to break now for a public service announcement. We'll come back and we'll talk about that and look forward and find out what you're looking for in terms of modifications of the law. And we talked before the show about the Arizona law and the Maine law, which which you will speak to that, those being better versions of public finance,
Right.
public campaign finance laws. This is Progressive Soup. I'm David Stevenson. We have Mike DeRosa and Richard Duffee. We'll be back in just a minute.
Hello, I'm Veronica Stevenson, Junior Services Librarian at the Danbury Library. Introducing your child to books and to the joys of reading opens the door to a world of learning. We have a large collection of books and non-print materials that you and your child will enjoy reading together. With your free Danbury Library card, you can take home books, videos, and lots more to enrich your child's life. Please visit the Danbury Library and give your child the best gift you can give, the gift of lifelong learning.
Welcome back to Progressive Soup. I'm David Stevenson. We have Mike DeRosa and Richard Duffee with us tonight. After we broke, you mentioned that Lowell Weicker had given a deposition to the court in this matter. Tell us a little bit about that deposition.
Yeah, former Connecticut Governor Weicker, who, of course, for a lot of people out here may or may not remember this, but he was successfully elected on a third-party line in 1990.
A Connecticut party.
A
Yep.
Connecticut party. He's a former U.S. Senator with significant name recognition and a significant political base. In the deposition, he said he had about 1,500 people working for him at the time that he ran for governor. And, of course, he had a lot of name recognition, as I mentioned earlier. And he indicated in the deposition that it is highly unlikely that he would have qualified as a minor party candidate under the recently reversed CEP, Citizens Election Program. And Weicker further testified that the organizational expenditures and the matching fund trigger provisions will put minor party candidates who lacked, quote, unlimited resources at a permanent disadvantage. In Weicker's opinion, those provisions meant that participating candidates are, quote, virtually assured of maintaining a spending advantage over any self-financed or non-participating minor candidates, because the matching funds mean that an independent candidate will never be able to outspend his participating opponent. And Weicker believes that the outcome of elections will be affected. Let me say that again. Weicker believes that the outcomes of elections will be affected. And so the point is, does the state have any real reason for affecting elections? I mean, do they really want to decide who wins and loses in elections? Do they have any public policy reason or any moral or common good reason for being involved in determining who wins and who loses? And I would say that that is the problem. You know, it's always a problem when you know, the map is not the territory. Okay, we understand this. So, I mean, I have to speak from my own experience, and there are sort of sub-triangles involved, for example, that disadvantage us, that are in that larger steel triangle that I talked about earlier.
Now, it's fair to say that everyone that's watching the show and everybody in Connecticut probably would agree on the fact that the Democratic Party and the Republican Party certainly have a vested interest in keeping this in place. I don't think anybody would deny
Right.
that, least of all them.
Right.
And there's another group, of course, that would like to see us lose our public financing entirely because they're PAC members, lobbyists, people that want cash to do the talking in elections as it's done in the past. Now, you mentioned before we came on about the Maine law and the Arizona law, which preceded Connecticut's law.
Right.
But before we get to that, tell our audience what you're looking for. What changes are you specifically looking for in the law to keep the law and yet make changes to make it a better law?
Well, let's link those two things because they are linked. How many signatures do Democrats and Republicans have to get in Connecticut? 0. Okay? How many signatures in Maine do Democrats and Republicans have to get? 0. How many do Greens and Libertarians in Maine have to get? 0. So the difference between our law and Maine's law and Arizona's law is that there are no petitioning requirements. Furthermore, in Maine, they require not $250,000 to run for governor. What you have is around 3,250 donations of $5 each, instead of, you know, I don't know how many $100 or less donations, $250,000 rolls out to. But you know, it is a real problem, and it's not a problem in Maine. One of the arguments on the other side is, well, you're going to have all these spurious candidates appear, all these mischievous parties appear, and that, you know, the judge in the case indicated that that is not true in Maine, based on his research. I mean, he didn't look at our research. He didn't look at the state's research. He did his own research. So it's a really solid document. And I mean, not only being 138 pages, he kind of leads the way. He says, the money is too high, the petitioning requirements are unconstitutional, and the organizational expenditures, in my opinion, are quite egregious, because the organizational expenditures add a further dynamic. If we, by some miraculous set of circumstances, qualify ourselves for through the monetary requirements or qualifications and the petitioning requirements, then comes in the third part of that iron triangle, which is the organizational expenditures, which allows political parties, 366 town committees, and 8 legislative PACs to dump unlimited amounts of money, spending outside of the campaign fund, but they can use it for radio, television, to say, Governor Rell, you should vote for Governor Rell, you should vote for the Democratic candidate for governor. This is really outrageous on its surface.
So it's above and beyond, this is above and beyond the spending of the individual candidates.
But the point is there's no caps. This is the point, and this is the keystone to any campaign finance law that's worth, its value in the marketplace. Caps are fundamental. Nobody understands this in the media. Nobody understands this in the public. There's probably 100 people who understand what's going on here, what's going down here. There was a reason that there were 40, 50, 60 lawyers in that room, because this is the sophisticated plan to create the new form of corrupticut in Connecticut. That is my opinion.
Now, you touched on the concern I think that a lot of people would have normally on having those lower limitations for everybody to get on the ballot, the concern that you'd have 150, 200, 300, 1,000 candidates for governor. And you say that, that in fact that's not the case according to what's happened in Maine and Arizona?
Absolutely, that is not the case. And the judge verifies this based on the last 3 elections. And he went back in the last 3 elections and looked at the experience. So, and actually our Green candidate, LaMarche, ran for governor there, and she got on the ballot, got $1 million, got 10% of the vote. And actually what happened was the Democratic candidate won, the Republican lost, and essentially, Maine's changing, but it's always been traditionally a Republican state. So I think that to get back to the major thrust here, what do we want? What we want is a campaign finance program, which is truly a campaign finance program. What we have here is not reform, we have deform. What we have here is a no incumbent left behind law. What we have here is the model for a new level of corruption that is would allow monies to go into the state party. This is a spurious approach that says, this spurious legal concept that political parties in Connecticut have more rights than you and I or other groups of people. Under this law, nobody can have a PAC except the political parties.
Yep. Again, back to the Maine and the Arizona laws, which preceded the Connecticut law. Other than the lower thresholds for candidates to get on the ballot, were there any differences beyond that in those 2 states?
Well, to be fair about it, there were provisions that you could get a partial grant if you collected 10% petitions of the registered voters who were in a particular area, or 15%, you would get a third of the grant, or 2/3 of the grant at 15%. Or if you did well in the election, you got 10% or 15% or 20%, you theoretically were going to get some money. That didn't work out. That was a mirage. What happened was they forced you to spend beyond what you were supposed to spend to get a reimbursement. So what would happen is, if you did well in the campaign, the only real benefit that you got was after the election, you wouldn't have to petition in the next election. So the whole point is we have what we would call the classic which came first, the chicken or the egg, okay? If you don't have the money to do well in the campaign, then you're not going to do well in the election, so you can't qualify. Again, a double bind kind of situation. And what we have to do is break out of this double bind, and I think that, you know, it's sad to me that the Attorney General and the Secretary of the State and the various other officials have gotten so defensive about this. Instead of looking at what the judge has put in the decision and trying to go into the legislative session, which they're in right now, they have a special session, and apply the law in a different way, change the system to make it constitutional, to make it fair, to put a level playing field, they're getting very defensive. They're saying we're going to take this case to the appellate court. They have every right to do so. But they're spending the people's money. They know they're going to probably lose. And more than likely, all they're really trying to do is to get through this election so they can basically put money in their pocket. Another aspect of this law I need to mention, I think it's important, is these candidates all get money for primaries. Minor parties are not allowed to have primaries in Connecticut.
Not allowed to at all have primaries.
Not government sponsored. So, and under this law, you know, if you're running for governor, you can get $1 million.
So you're limited to a caucus and no primary.
Right. Well, they say you can determine whichever way you want to come up with your candidate. Now, this assumes this gentleman here actually had an opponent when he ran for Congress last year.
Correct.
The assumption is that Green Party's members would not disagree with each other about who should represent them in the congressional election. And this is just spurious and untrue. And I mean, my point of view is, again, I feel like a crash test dummy. Some experiment is being loosened on no matter what we do. Our purpose is basically to crash our political car into a wall, you know, to experiment. And you know, it's been 3 years now in this case, and I know I'm very passionate about this, but I'm also very compassionate because I think this is about democracy. I think this is about change. I think this is about bringing home to the people of Connecticut that this state has a right to hear all points of view.
Now, you mentioned, I want to go back to that 400,000, the graphic, the 400,000 signatures that are necessary. Net signatures, in order to get however many signatures. What is the logic behind that? We're wrapping up now, but quickly, what's the logic behind that? What was the state's logic behind that?
Well, the logic of requiring 10, 15, or 20%, the judge asked them, and they said, well, this came from the research division of the legislature. And he said, well, the problem with that is that...
We're going to have to wrap it up there. We'll have you back on, Mike and Rich, and talk about it. I'm David Stevenson, Mike DeRosa, Rich Duffee, and this is Progressive Soup. Thank you for joining us this evening. Enjoy your evening.